Detective Donnelly assumed it would be an easy victory, a vocal teenager with zero legal education. What caught him by surprise was her construction of a case so compelling, it shattered his professional reputation in a packed courtroom. The judicial chamber wasn't silent, not exactly. You could detect the whirring of an old ventilator in the edge of the room, the subtle scratching of a secretary's writing tool, the rustling of inexpensive synthetic seating. But everything seemed frozen when Ariel Manning entered. She wasn't clothed to dazzle, merely a dark blue jacket, beige trousers and comfortable shoes. The sort of ensemble you'd done for a school competition or a weekend religious service. But she carried it as protection. Her locks were secured into a basic knot, spectacles situated near the bottom of her face. She appeared composed, in command, like someone who'd already completed the final section of a novel. Everyone else was still browsing through at the defendant's station. She lowered herself carefully. No attorney beside her, just herself, 17, charged with impeding justice by herself. And that's when Officer Richard Donnelly chuckled. It wasn't boisterous but audible enough for the court officer to look in his direction. A slight grin formed at the edge of his lips, as if he was viewing a poor comedy. He already anticipated the conclusion to Judge Raymond Keyes, glanced upward. "Miss Manning, you're defending yourself today." "Yes, Your Honor," she replied. Her tone was fluid, distinct, no indication of anxiety. Donnelly reclined in his position at the prosecutor's desk, folded his limbs. "This'll be rapid," he whispered under his breath. Ariel didn't even react to the remaining spectators. It seemed uncomplicated. A female from the Eastern District of Phoenix attempting to be clever. Another detention become routine. Just another file number. But what they weren't aware of, not yet, was that Ariel Manning had dedicated the previous 4 weeks preparing. As if her destiny hinged on it, because it did. She examined the chamber, gaze pausing briefly on her parent. In the last row, her mother didn't grin. She was scarcely inhaling. Ariel offered a tiny confirmation, not for reassurance, but for acknowledgement. She understood this. The court officer announced the proceedings. The State of Arizona versus Ariel Elise Manning, case reference 22 to 1.35b, single count obstruction of justice, single count interfering with police operations. Ariel stood prepared. "Your Honor." The magistrate peered down at his documents. "Miss Manning, I've reviewed the accusations. You've surrendered your entitlement to counsel. I must caution you, this isn't a minor infractions court. You will be held to identical standards as a certified attorney." "I comprehend, Your Honor." Donnelly shook his cranium as if he couldn't accept this was genuine. A young woman like her quoting judicial codes, debating her own defense to him. It was comical, but here's what he wasn't aware of. Ariel hadn't been squandering time since that arrest. She hadn't been celebrating or missing classes, or publishing online about how unjust existence was. She'd been consuming information, analyzing, observing courtroom footage on public archive websites, contacting legal assistance hotlines using a fabricated identity, just to hear how authentic lawyers dissect a legal matter. And most significantly, she'd been re-watching that recording from her damaged mobile device, repeatedly, because when she'd initiated recording that afternoon outside Roosevelt High, she wasn't attempting to become viral. She was attempting to safeguard someone. Her schoolmate D'Angelo had been thrust face first into a barrier during a disagreement about a damaged storage compartment. Donnelly arrived agitated and yelling, and when Ariel intervened, not actually touching anyone, just inquiring what on earth he was doing, she got handcuffed, forced into a police vehicle, and documented for impeding an officer in the execution of his responsibilities. The video didn't deceive, but back then no one was concerned. Now it was evidence, but that emerges later. Presently Ariel adjusted her vision aids, extracted a collection of neatly arranged paperwork from her folder, and positioned them before her. Donnelly appeared disinterested. She appeared prepared, but pride has a tendency of collapsing beneath the pressure of reality, and that reality was about to make the audience pay attention and listen. It transpired on a Tuesday, scorching arid, the type of Arizona temperature that causes metallic fences to feel like cooking surfaces. Academic hours had just concluded. Ariel was lingering near the intersection of South 13th Avenue and West Adams Street, partially listening to audio, partially navigating through a collective assignment conversation. That's when she detected it. Elevated voices, a gathering starting to form. She stored her device and moved toward the commotion. A pupil, D'Angelo Ruiz, a third year with a reputation for being noisy but harmless, Was disputing with a campus security personnel. Something regarding a storage unit being forcibly accessed. Someone accusing him. But it wasn't D'Angelo shouting. It was the grown-up, the individual in uniform. And then Officer Donnelly appeared. He wasn't school protection. He was Phoenix Police Department designated to that region. Following a recent increase in minor offenses, everyone recognized him. Large rectangular shoulders. Eyewear always accessible. Always situated close to his waistband, as if he was anticipating a justification. Ariel had observed him previously. She'd witnessed how he communicated with youths, not as if they were individuals, but as if they were issues. This instance was no exception. Donnelly rushed over, didn't pose a single inquiry, just seized D'Angelo by the limb. The youth pulled back instinctively. No strikes, no threats, just terror. And that was sufficient for Donnelly to propel him against the barrier. Ariel paused for half a moment, then retrieved her phone. "You can't do that," she stated. He didn't commit anything. Donnelly glimpsed at her as if she was adhesive on the underside of his footwear. "Retreat," he commanded. "Now, I'm documenting this," Ariel declared, her voice stable, but sufficient for the other students to perceive. "You didn't even ask what occurred. You want to meddle," Donnelly announced, now releasing D'Angelo and advancing toward her. "You want to become involved." Ariel didn't recoil. "You're not authorized to employ excessive power without reason. I understand my privileges." "You comprehend your privileges," he echoed mockingly. "How about you learn the repercussions?" And just like that she was thrust against the patrol vehicle, appendages behind her back, device snatched from her grasp. "You can't," she began, but he was already securing the restraints. "Obstruction," he proclaimed loud enough for his body camera. She interfered with police action. Students inhaled sharply, a few retrieved their own devices. But the injury was inflicted. By the time Ariel's mother arrived at the station, she'd already been fingerprinted, processed and informed she'd have to confront a judge. The periods that followed weren't noisy. They were hushed, weighty. No attorney would accept the case without payment. Public defenders were overwhelmed. Her mother worked additional rotations at the VA hospital, and didn't possess the finances to contest it, so Ariel undertook the task herself. She recalled what her aunt used to express: "If you desire someone to listen to, you first master their dialect." That evening she viewed 4 hours of courtroom videos on YouTube. The subsequent evening 6, she initiated noting terms she didn't comprehend, and researching them she printed the police statement, read it, sentence by sentence, emphasized every falsehood. She contacted her cousin's partner, a legal assistant in Flagstaff. They didn't communicate often, but when she heard the account, she transmitted Ariel a catalog of resources, legal statute PDFs, public case documents, video instructions. It was like tossing combustion into fuel. Ariel didn't simply study the law, she internalized it. She discovered what judges search for when an individual represents themselves. She located cases where youthful individuals fought accusations and prevailed. She even rehearsed introductory statements in the reflector, recording herself on a loaned tablet, to analyze her bearing and inflection. Education faded to secondary importance. Her instructors sent electronic messages, some extended support, others didn't respond. But one, Mr. Kirkwood, her history instructor, observed, "You're not abandoning, are you?" he inquired, one afternoon when she remained after instruction. "No," she replied, "I'm just preparing." But the aspect about preparing is individuals rarely notice until the illumination shines, and then they question how you ever remained imperceptible. Initially Ariel didn't train like someone hoping to succeed. She trained like someone who had no alternative, but to every morning commenced identically awaken before daybreak, clear off the cooking surface, and unfold her organizer. It was substantial now, 3 inches thick, packed with printed regulations, handwritten observations, adhesive markers, in fluorescent shades, and sheets of records from other legal proceedings she'd discovered online. She identified everything: yellow for essential terminology, blue for inconsistencies, red for Donnelly's contradictions. She had observed her own detention video. More than 30 instances. She learned to analyze it, frame by frame, indicating the precise second Donnelly grabbed D'Angelo. The instant she vocalized the duration, her hands were observable. What she didn't do was weep. Her mother Patrice had wanted her to accept a bargain. "We can't afford to risk, sweetie," she murmured one evening over warmed-up casserole. "They have the badge. They have the judge. You don't triumph in environments like that." Ariel didn't reply immediately. She just masticated slowly, then pushed the dish away. "I'm not attempting to triumph, Mother. I'm attempting to demonstrate I don't intimidate easily." That stillness disturbed Patrice more than yelling would have subsequently that evening. Ariel sat isolated in her chamber, a portable computer borrowed from Mr. Kirkwood, balancing on a cushion. The radiance illuminated her visage, while the indicator flashed on a text document, labeled Opening Statement version 4 each occasion. She recited it audibly. She detected something novel, a turn too gentle, a row too sentimental, a phrase that didn't resonate as hers. She didn't desire to appear irate. I meant vociferous irate, caused individuals to cease listening. No, she needed to sound measured, not because she wasn't furious, but because it frightened them more when a young woman like her knew how to maintain her composure. One afternoon, she phoned the legal assistance hotline again. This occasion she requested to converse with someone familiar with excessive force matters. The female on the connection sounded fatigued, but compassionate. "Are you submitting a grievance or confronting charges?" "Both," Ariel replied. "Technically."
"Okay, do you have representation?"
"I am my representation." There was a hesitation, then a gentle laugh. "Well, damn all right. What's your designation?" Ariel hesitated, then provided it for the initial occasion. Over the subsequent half hour they evaluated her statement. The woman Jeanette informed her which segments of the statute the district attorney would likely emphasize. She cautioned her how judges tend to react to adolescent defendants without counsel. "Don't attempt to sound intelligent," Jeanette expressed at one juncture. "Attempt to sound assured." That line adhered. She inscribed it on an adhesive note and attached it to the summit of her organizer. "Don't attempt to sound intelligent. Attempt to sound assured." In her available moments, she practiced before reflectors, before her mother, even once before 2 children in her neighborhood, who typically just engaged in electronic entertainment on her entrance. "What if the judge disrupts you?" one of them inquired. "Then I pause, and when he's completed, I ensure he hears me nonetheless." Mr. Kirkwood proposed to be a personal reference. Her cousin's partner transmitted her a PDF regarding how to structure cross-examinations. Even the campus custodian, Mr. LaRue, who barely uttered a complete statement most days, handed her a legal dictionary he maintained from his evening classes back in 2002. Individuals began to support her, not because she requested them to, but because she never solicited sympathy. They perceived how earnest she was. But Donnelly didn't. He still believed this would be a brief trial, a girl with no education, no qualification. He figured he'd mention a few technical terms and exit unblemished. He had no conception that the adolescent seated opposite him had prepared more thoroughly than most attorneys he'd encountered in actual courtrooms. But conviction has a tendency of fracturing when it's compelled to confront truth with amplification. And Ariel was prepared to communicate. The courtroom appeared different. The second instance, this wasn't an arrangement. This was the hearing. Identical judge, identical overhead ventilator. But now the positions in the rear were fuller. Several educators from Roosevelt High had arrived. D'Angelo occupied a spot near the front, his mother beside him, and somewhere in the back angle with her documentation out, sat a journalist from the Arizona Daily Sun. Someone had alerted her about the young woman defending herself against a law enforcement officer. Ariel stood as the judge entered. "Be seated," Judge Keyes directed, adjusting his spectacles. The court officer glanced between Ariel and Donnelly. State of Arizona versus Ariel Manning, trial in progress. The prosecutor delivered a monotonous introduction. She characterized Ariel as disruptive, disrespectful, someone who intensified an already tense circumstance. Donnelly sat behind her, limbs crossed periodically, smirking as if this was just another routine assignment. Then it was Ariel's opportunity. She proceeded to the middle, notes in grasp, but she didn't consult them. "Your Honor, ladies and gentlemen of the tribunal," she initiated, gazing directly at them. "I'm not an attorney. I won't claim to be something I'm not, but I can definitely attest to what my eyes witnessed." And what's even more significant, I can speak to my personal experience. I'll allow the evidence to make my case. She made her way back to her seat with straightforward, refined poise, yet with assertive presence. The judge gave a subtle nod, clearly appreciative. Subsequently, the testimonies began. The prosecution summoned Donnelly initially. He approached the witness box with confident familiarity. "Officer Donnelly," she initiated. "Are you able to recount the events that transpired during the afternoon of September 12th? Donnelly moved closer to the microphone. "Certainly, I was dispatched to Roosevelt High in response to a call about a confrontational student. Upon my arrival, the confrontation had worsened. I subdued the student to ensure everyone's safety, when this juvenile female started yelling, hampering my capacity to control the situation." Ariel listened attentively while taking notes. After the prosecutor concluded, the judge turned toward her. "Your witness." Ariel rose, pulse unwavering. "Officer Donnelly," she addressed him, "what is the duration of your service with the Phoenix Police Force?" 17 years. "And throughout those 17 years, on how many occasions have you taken a student into custody for obstruction without any physical confrontation occurring?" Donnelly lifted an eyebrow. "Multiple times. It varies based on the perceived threat." "Did I pose any danger to you, officer? You were shouting. I couldn't concentrate on the environment." "Is it accurate that I was positioned 12 feet away?" He hesitated. "More or less. You never instructed me to vacate the vicinity. You commanded me to step back. Is that normal procedure? Is seizing a student by their neck also considered normal procedure?" The prosecution objected. "Assumes facts not introduced into evidence." "Sustained," ruled the judge. Ariel inhaled deeply, shifted approach. "No additional inquiries at this moment, Your Honor." She returned to her place with composure. The prosecution brought forward 2 additional witnesses, one campus security guard, who vaguely recalled observing Ariel filming, and a classmate who admitted they weren't really paying much attention. Then Ariel's opportunity to present her witnesses arrived. She first called upon Mr. Kirkwood. He characterized her as intelligent and motivated, someone who never initiated problems. She was the person students approached when they struggled with homework. He testified. "You wouldn't anticipate someone of her character to behave rashly." Next came D'Angelo. He took the stand, anxious yet forthright. "She was assisting me," he declared. "She never made physical contact with anyone. She merely inquired about what was happening." "Did she make any threats toward Officer Donnelly?" "No." "Did she physically interfere?" "No. She just held her phone out. That's all." Ariel nodded, faced the judge. "I'd like to submit video footage as evidence," she stated. "It was recorded on my mobile device during the incident." The judge permitted it. The recording played. The sound quality was somewhat static-filled but sufficiently audible. You could clearly hear Donnelly yell, observe him shove D'Angelo, and hear Ariel's voice, not screaming, not threatening, just questioning, "What are you doing?" When Donnelly grabbed her, the camera angle shifted, but everything remained audible. Soft gasps echoed throughout the courtroom. Ariel avoided looking at the screen. Instead she observed Donnelly. For the first instance his self-assurance wavered, but the reality about honesty is once it's revealed publicly, it doesn't retreat quietly. The absence of sound after the video concluded wasn't merely silence. It was profound. Even the judge reclined in his chair, fingers pressed together, gaze fixed on Donnelly. He cleared his throat. "Officer, would you care to address what we've just viewed?" Donnelly adjusted uncomfortably. "The footage doesn't capture the entire exchange, Your Honor. It fails to show my perspective." She was instigating a tense situation. Ariel stood. "Objection. That's a personal interpretation, not a factual clarification." The judge glanced at her. "Sustained. Officer, restrict your comments to verifiable details." Donnelly attempted again. "I viewed her conduct as threatening." Ariel didn't display rage. She appeared prepared. "Officer Donnelly," she said, resuming her cross-examination, "in your initial police documentation, you stated, and I'm quoting, the individual approached aggressively, shouting and refused to comply with verbal directives. Is that accurate?" "Yes. But in the video, my tone is measured. I'm stationary. I never advance toward you. Recordings can be misleading." "I concur. That's precisely why I've provided a timestamp analysis." She displayed a printed screenshot. "This image shows my position. This image, captured 5 seconds later, depicts me in identical positioning, without movement, without advancement, simply standing. Would you like to contest the timestamps? The courtroom fell silent. I'm not an expert in video analysis, Donnelly replied. That's acceptable. I've submitted this recording for professional evaluation by a digital specialist from Northern Arizona University. I can summon her as a rebuttal witness. The prosecutor quickly interjected. Your Honor, I'm entirely within my legal entitlements. Ariel countered. I disclosed the witness 2 days prior. Judge Keyes raised his palm. She did. It's documented in the file. Ariel slowly returned to her seat, composed like someone who had strategically positioned a game piece and already anticipated the subsequent 5 moves. The analyst confirmed the recording's authenticity. No manipulation, no tampering, no movement from Ariel during the period she supposedly approached aggressively. Donnelly's testimony was now scrutinized. His reliability began to dissolve. Then Ariel executed one more strategic action. Your Honor, she stated, I petition the court to examine prior grievances lodged against Officer Donnelly, specifically the 3 submitted within the past 5 years. 1 from a guardian at Dunbar Elementary, 1 from a convenience store employee, and 1 from an individual he detained during a roadside stop last November. The judge arched an eyebrow.
You're referencing public misconduct files?
Yes, sir. All accessible through a Freedom of Information application. All submitted, but never adjudicated. The prosecutor rose. Your Honor, those are unsubstantiated allegations, which is why I'm not asserting culpability. Ariel responded, turning to address the courtroom. I'm requesting the court to recognize a recurring pattern, a pattern of excessive reaction, a pattern of focusing on individuals who raise questions. I'm not his initial encounter, just the first one who arrived with documentation. A subtle wave of hushed reactions swept through the audience, not boisterous but palpable. Donnelly resembled someone realizing the space no longer belonged under his control. The judge announced a temporary adjournment. When proceedings recommenced, his manner had transformed. He was more grave now, deliberate. I've examined the footage and weighed the testimony presented, he began, and I harbor reservations. Miss Manning, your presentation of evidence, your interrogation approach, and the background you've introduced establish reasonable doubt. The prosecutor remained rigid, mouth compressed. Therefore, Judge Keyes proceeded. The accusation of obstruction is dismissed. Ariel remained motionless. She didn't grin. She just gazed forward, as if her physical self hadn't processed the declaration yet. I will also be forwarding an official recommendation for examination of Officer Donnelly's behavior, including historical complaints and his actions in this instance. That's when she released her breath. No jubilation, no ovation, just a quiet, steady exhalation. The type you take when you finally release something burdensome, but vindication never concludes matters. It's merely the juncture where people begin wondering how you shouldered the burden for such duration. When Ariel exited the courtroom, the daylight felt different, not in some poetic sense, just more intense than she recalled, more defined. Her mom was waiting just beyond the entrance, arms folded firmly across her torso, as if containing an internal tempest. Ariel remained silent. So did her mom. They simply embraced, not the prolonged cinematic embrace, but the kind that communicates, we survived. Let's breathe now. D'Angelo approached with his parent. You were incredible in there, he remarked, his voice partially hushed. I had no idea you could accomplish all that. Neither did I, Ariel answered, until necessity demanded it. The journalist from the Daily Sun lingered nearby, notebook prepared, but Ariel gently declined with a headshake. Not at this moment, not yet. Throughout the following week, the narrative circulated, not explosively viral, not front-page material, but sufficiently. The published piece dubbed her, the adolescent who defended herself and compelled the judicial system to listen. Opinion columns emerged. School administrators initiated discussions regarding police presence within educational facilities. People telephoned her residence to provide collegiate opportunities, mock trial scholarships, even mentoring programs from African American lawyers across the state. But Ariel wasn't concerned with recognition. She valued the official record. That video, the one they claimed lacked significance, was now integrated into an official grievance. Donnelly had been temporarily suspended from duties. Internal Affairs had launched an investigation. Naturally, some continued supporting him. That dynamic rarely evolves. He was merely performing his duties. She should have remained silent. Why document everything? However, for each voice expressing such sentiments, two more were saying. She maintained her position. She understood the legislation better than they did. She transformed something. At Roosevelt High, students began formulating questions differently in classrooms, more incisively. Teachers noticed. Some embraced this change. Others remained reticent. But the dynamics had altered. One afternoon, Mr. Kirkwood requested Ariel stay after classes ended. I used some connections, he revealed, sliding a manila envelope across his workspace. There's a summer initiative at Arizona State, law exposure, mentorship, simulated court proceedings. They accept 20 participants. I've already forwarded your name. Ariel opened the envelope, reviewed the application. She didn't weep, didn't chuckle, just nodded once. What motivated you to pursue this? He inquired. I mean genuinely. She contemplated briefly. It transcended my personal situation. It was about ensuring the subsequent youth in my position doesn't face choosing between silence or incarceration. He relaxed against his chair, smiling gently. I believe you've acquired more than documentation now. She laughed for the first time in weeks. Later that evening, Ariel again sat at the kitchen table, this time not surrounded by notes, but with a clean piece of paper. She inscribed one sentence across the top. They assumed I appeared to defend myself, but I arrived to uncover the reality. She couldn't predict her future trajectory, but now for the first time, she had agency over what followed, on her own terms. The narrative wasn't simply about a young woman who overcame an unjust accusation. It concerned what transpires when you prepare discreetly, communicate with precision, and decline to be marginalized. Ariel Manning didn't seek confrontation, but when confronted, she didn't falter. She researched. She remained resilient. She demonstrated that exceptional intelligence doesn't necessarily wear formal attire or possess official titles. Sometimes it manifests as an adolescent carrying a binder filled with printed materials, a smartphone, and the bravery to declare, "That's unacceptable." Because justice doesn't invariably descend from authority figures. Sometimes it originates with someone nobody anticipated. If this narrative resonated with you, distribute it. Someone somewhere needs reassurance that their perspective matters, and if you haven't already, subscribe. We have more narratives forthcoming, stories that don't merely communicate, they remind us what deserves our advocacy.